Every day in the USA, people find themselves in court.
The defendant, identified as Alyssa Genovese, as a front seat passenger, and initially provided them with a false name of Shannon Picking, with a date of birth of 11/25 of 91. Officers detected an odor of alcohol intoxicants emanating from the driver, who became extremely nervous and began speaking fast. The driver was asked to exit the vehicle, where officers conducted several standardized field sobriety tests, at which time he passed, and he was returned to the vehicle. Officers then conducted a lien SOS inquiry on the false name provided by the defendant. Per lien SOS, the name given did not have a valid return or result. Officers again met with the defendant, who was unable to provide officers with any form of picture ID, and claimed that she lost her ID at the bar. Officers noted that the defendant became nervous and attempted to change the subject several times and said that she just wanted to go home. Officers asked the defendant to exit the vehicle, at which time they called for a second police unit with a mobile fingerprint scanner. The defendant subsequently provided her real name to the officers, which was confirmed per lien via SOS. The defendant was then advised she was under arrest for a local charge of fraudulent schemes. During the search of the defendant's belongings incident to an arrest, they located several hypodermic needles, drug paraphernalia, in addition to crack cocaine and heroin with methamphetamine, along with several prescription pills in a unlabeled pill bottle. The defendant was then transported to a station where she was booked and held. The recovered drugs were field tested positive as fentanyl and heroin and cocaine, and the cocaine weighed about 2.7 grams, and the recovered fentanyl and heroin weighed about 3.12 grams.
All right, upon examination of the complaining witness, the court does find that the offenses charged were committed and there's probable cause to believe the defendant committed those offenses. Counsel?
Your Honor, good morning. Richard P. Serrano, Your Honor, I appear as appointed MIDC counsel on behalf with my client, with the Chief President in custody there somewhere.
Ma'am, please step up.
State your name, ma'am.
Alyssa Lee Genovese.
Did that come through?
Yeah.
Your Honor, here for arraignment purposes only. I've explained to her, my client, the nature of the charges, all maximum penalties involved as to both counts. She understands them both. She was an advisor of her advice and rights. I believe she understands those as well. Thereby today we waive formal rating, stand mute, ask for a plea not guilty to be entered on her behalf for arraignment purposes.
Okay. And the court will waive the formal reading. Ma'am, you do have the right to have an attorney represent you, and you have had an opportunity to speak to an attorney today. Is that correct?
Yes, ma'am.
All right. The court assigned the order for appointing an attorney for felony matters. You have the right to be presumed innocent and to prove me guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes, ma'am.
All right. The court's going to turn your plea of not guilty on your behalf, scheduling this matter for probable cause conference on April 2nd at 8:45 a.m. And counsel, as to bond.
Your Honor, my client is 34 years old. She's single. She supports 2 minor children, ages 8 and 6. She's not working at this time. She recently lost a job. And Your Honor tells me, well, you see her criminal history before you, but she tells me she's not on probation or parole anywhere, but she does have a matter pending in Dearborn. I believe it's a traffic matter of some type. With that, Your Honor, I explained to her the serious nature of the charges, that more than likely there would be a monetary bond levied by the court, but we're asking either for a personal bond, Your Honor, or a bond she can reasonably expect to post, given her circumstances. As I said, she does have two minor child that she's like to be able to continue to care for.
Okay, ma'am, how old's your child?
Two.
My children are ages 6 and ages 8.
Okay, and so who are they with right now?
Grandparents and father.
Grandparents and what?
The grandparents are father.
Okay, are there two different fathers?
Yes.
Okay. So one's with grandparents and one's with the father.
They're both with father. Well, one has been in her life since I was pregnant with her. The other father is deceased. So
Okay. So if I understand this correctly, there's two fathers. One of the children's father is deceased. I'm going to presume it's the older one, but I could be wrong. And then, but the father of the other child has been in the life of the child whose father is deceased the entire time. And so he has both children.
yes.
Okay. And so, ma'am, when's the last time that you were employed?
About 6 months ago.
And where were you employed?
I waitress.
Okay, ma'am, am I supposed to guess where you waitressed? I asked where you were employed.
Oh, I'm sorry, Joe's Hamburgers.
Okay. And so how long have you been employed there?
About 6 months.
And why are you no longer employed there, ma'am?
Transportation issues.
I'm sorry?
Transportation issues.
Okay. So how are you supporting yourself and your children?
I get $1,500 a month. And with the father, we separated together. So I
Wait,
get
I'm sorry. You get $1,600 a month for what?
Social Security.
Is that a death benefit that your child receives as a result of her father's death?
Right. So we use that to take care of the
Okay.
children.
Man, that's your daughter's money, not your money. Let's be clear on that. That's for
Right,
your
well,
daughter.
Used to take care of the children.
Right. He had one child, correct?
Right.
Right. So it's not for you to live off of, it's to help support the one child that he had at his death. So that $1,600 isn't to be used to support your entire family, ma'am.
No, my child's father, he works as well.
If you're in a test right now, ma'am, what's in your system?
Opiates and benzos and cocaine.
Do you have prescriptions for any of those, ma'am?
No,
What's the matter that you have pending? Is it Dearborn or Dearborn Heights?
Dearborn.
And what is that for, ma'am?
It's from 2011.
It's what?
Possession of paraphernalia.
I'm sorry, what did she say?
Paraphernalia possession.
Oh, paraphernalia. I couldn't understand.
I thought she had told me it was a trap.
Okay. And you're not on probation still for your matter. No, that is the matter you're on probation for in the 19th District Court in Dearborn. You're on probation for that matter, correct? Or no? You have a new matter?
No, I'm not on probation.
And so you have a new matter for that, for Dearborn?
No.
Okay. So ma'am, do you have a pending matter right now in another court?
No.
No. Did you successfully complete your probation in the 19th District Court?
Yes.
Detective, would you like to address bond?
Your Honor, I would recommend a $10,000, 10% bond and a GPS tether to reassure the defendant's next court appearance. Per lien SOS, looks like the defendant resides in Canton, Michigan. So again, just to reassure her next court appearance.
Do you live in Canton or Southgate, ma'am?
Cascade.
How long have you lived in Southgate?
Probably 5 years.
5 years?
Yeah.
Well, are you aware of the requirement that you have to change your license with the Secretary of State?
I don't have a license.
Your identification, ma'am. Anything. You don't have a license,
Your Honor, I wanted to note also, my client has told me that she has not had her methadone in 2 days that prescribed for her. So if she cannot post a bond, then, or it doesn't answer to custody, then I'd ask the file be marked medical.
I can mark a medical counsel, but I don't know that she'd be able to receive her methadone anyway at this point if she's still under the influence of some of the substances. I don't think she can take methadone and some of those substances simultaneously, but I'm not a medical professional, so I will mark the file medical. It does appear. I'm sorry?
I think you tell me you're in custody 3 days, ma'am, here?
I'm sorry. Yes.
How long you been in custody? Since Friday?
Friday.
Okay. Well, it also shows that your client does have a history of failing to appear because she had the matter that you referenced, counsel, that you thought that was still pending was from 2011, and she took care of it in 2024. So the court does have concerns that not only for the safety of the public, but that Ms. Genovese is not going to return to court. But also, ma'am, are you interested in treatment?
Yes.
Great. What I'm going to do is I'm going to order a $20,000 personal bond, defendant to be tethered to treatment through the Wayne County Jail. And so then counsel, I will still mark the file medical, but I believe that she will be evaluated when she's in treatment regarding any medications.
Thank you.
And detective, just so you're aware, since I'm tethering Miss Genovese to treatment, the language has to read as a personal bond for the jail purposes, so then they can tether her to treatment.
Very well, Your Honor. Thank you.
You're welcome. We'll see you back on April 2nd.
Thank you.
All right.
Have a good day. Okay. All right. We are on the record in the matter of the City of Wyandotte versus Corey Skinner, 26374 A, B, and C.
Good morning, Richard T. Serrano, P33828, appearing on behalf of with Ms. Skinner. Ms. Skinner, could you stand up, please?
All right, ma'am. Good morning. Your name for the record, please.
Corey Lynn Skinner.
Right. I believe your client's been here before, right?
No.
No?
No.
Okay. Somehow, I think, did I represent you previously, ma'am?
No, I used to work at the PLED for the Wayne County Detectives Association meetings.
Used to be what?
I think you were at the Wayne County Detectives Association meetings
Okay.
at the PLED. I used to work there.
Okay. Somehow I have your client. Somehow I have your. Did I ever consult with you, ma'am, when I was in private practice?
Oh.
Well, somehow I have your client's phone number in my phone that I used to I must have met with her on some legal matter at some point. So I just put that all on the record. I've deleted it now, but I just wanted to put that all on the record. I haven't had any communication with your client. I don't even know if I've even had any communication.
You were never retained as their attorney, Your Honor?
I don't believe so.
No.
I don't believe so.
Yeah.
I think there may have just been some do you have a relative named Anita?
Yes.
Okay. So that may have been because I think her mom may have contacted me about something with did you have young children at one point? Was there a custody
Yeah.
issue or something your mom wanted guardianship of or something, or?
My daughter lived in Tennessee. That might have been it.
Oh, that may have been it. So I just wanted to put all that on the record, counsel, so that, because your client's name is very, very familiar. And since she hasn't been here before, I looked in my contacts and somehow I had her name in my phone, but I haven't had any contact with your client nor her mom in probably, I'd say 15 years.
Okay, Ms. Skinner,
I'm sorry, as far as that goes, but I also haven't been to one of the Wayne County detectives meetings at the PLAV probably in about 8 months or a year or something, I think. So I haven't
Yeah,
seen
it's
her there
been
either.
like
What's that, ma'am?
It's been like 3 years since I worked there, but I
Oh,
didn't. So
okay. So counsel, is there any objection to this court continuing, or do you want this court to disqualify itself? I don't think that I would have any issue being unbiased. I don't think I have any bias since I haven't had any contact with your client in a number of years. And the other matter was probably almost 2 decades ago, but
well, I know the court has good memory and we appreciate the court disclosing. Ms. Skinner, do you have any objection to this court hearing this present matter, knowing that there in the past may have been some remote contacts?
no.
We have no objection, Your Honor.
okay. All right. So court will note conflict waived. And I'm sorry, ask the arraignment counsel.
Mr. Raven, Your Honor, we wait for reading stand mute. I've advised her of all of her rights, the nature of the charges pending against her. She understands both. And we can only plead not guilty today, have it set for a plea trial.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, schedule this matter for pretrial on, well, we'll do April 1st, but counsel, we're at almost 100 cases on April 1st.
I'm sorry?
We're at almost 100 cases on April 1st. So just
Court's discretion, Your Honor.
just so you're aware, unless your client wants to waive time and have it heard on April 8th.
That's fine.
We have no objection.
Okay.
April 8th might be better.
All right. I will indicate April 8th.
10:15.
At 10:15 a.m. As to bond counsel.
Mr. Bond, my client tells me she is single, not on probation or parole. She supports no minor children. Nothing pending in the world. She's 39 years old, as stated, has had some college education. She lives presently with her mother. And Your Honor, she is employed in 2 places, both as a bartender, one at Denny's Gin Mill and one at, I marked it down, but I forgot. What was the other name of the other bar? Oh, something Time. Quitting Time. There you go. Okay. So we ask the court to consider a personal bond or bond she can reasonably expect to post given the circumstances, Your Honor. Thank you.
All right. And so, ma'am, is your address in Lincoln Park accurate?
Yes.
All right. And do you have any other pending matters?
No.
Have you ever failed to appear in court for any reason?
No.
And you're not on probation or parole, is that correct?
No, ma'am.
If you're to test right now, ma'am, what's in your system?
Possibly cocaine.
And when's the last time that you used that?
Saturday before a concert.
All right. The court's going to, in this matter, the court, as to count A, the court's going to order a $5,000 10% bond. The court's going to order a $5,000 personal bond as to counts B and C. The court has concerns for the safety of the public, given the allegations in this matter, and that the allegation of the alcohol content of your client was a 0.258, which is very high. The court's going to also order that your client is to not be released from an alcohol tether from the Wayne County Jail. So, ma'am, if anyone's buying you shots at work, you can't take those.
Oh, no, I'm not anymore.
All right. You're gonna copy these bond conditions, but you're also, ma'am, not to be released from alcohol tether from the Wayne County Jail.
Thank you, Your Honor.
Thank you. Have a good day.
You gave the cops a fake name.